Hi, I'm Tom Eschert, and this is Power in Politics, the conversation about the biggest issues that are impacting you in New York State, or even beyond that in this country right now, with the people that are making decisions, the advocates that are invoking change, and everyone in between. Today we sit down and speak with a judge, a former judge at that, Jim Murphy, formerly of Saratoga County, just retired a few months ago. He's now working for BN Communications, so we ask him a bit about that transition, what he's doing now, and also what he did before, looking back at his career, and of course, we apply all of that to what's going on right now in New York State when it comes to discovery reform and some of the changes that are being proposed to those laws. What he has to say about that, what he has to say about bail reform, and then on the national level, the narrative going on right now about judges that some say are getting in the way of President Trump's executive orders. So, of course, tune in as always on our podcast at Power in Politics or on our YouTube page to see the video version at CBS 6 Albany. We are joined by the now former judge, Jim Murphy. Thanks so much for coming on with us.
Thanks for having me today.
Of course, a very long, decades tenure in Saratoga as both a judge, a DA, and now working for BN Communications on behalf of them with a lot of different aspects there. So congratulations on that.
Thank you very much. It's been a long and varied career. I'm very excited about the next chapter.
Yeah, well, let's just start with, looking back holistically, at everything that you've seen in your days before this next step in your career. What did you appreciate the most about it? Where did you find the most value?
Well, it's been a long career. It's been 37 years between the district attorney and the judgeship. And so I've dealt with thousands of cases, thousands of victims, lots of police agencies, kinds of cases. And I think it's always the thing that I liked the most about it was that I could help deliver substantial justice to the residents of the county. I could help victims who had been wronged in the DA's office. I could make important decisions as a judge and hopefully be fair and patient, treat the litigants with respect, and make the right decision.
What was it like now that you've had a chance maybe over the past few months to look back on it, going from DA to judgeship, going out from one side to another?
Yeah, the DA job, you're an advocate, right? You're in court every day advocating for the law enforcement agency or the victim of the crime who had something happen to them or some criminal conduct. As a judge, you're really a referee. You're really there just to enforce the rules and make sure that the people in front of you, defendant, prosecutor, are treated fairly, that they follow the rules of evidence, and that the right verdict is reached by a jury.
Why was now the time to take a different step in your career?
Well, I was doing this for 37 years, and I felt like I'd sat in every seat in that courtroom,
Yeah.
and I had done it, and I was ready for a change. My term had ended. I felt like I wasn't wanting to run again for another 10-year term, and I had dealt with media and police and lawyers and press, and I thought this would be a natural pivot to a communications firm.
Yeah, what are you doing with that now? What does that entail, and how different is that for you?
It's similar in a lot of ways in terms of giving advice to people and kind of analyzing a situation, a problem that might be legal, it might be press, it might be personal, and I can advise them given my experience. So I'm really using the same skill set that I used as a DA and as a judge, now just in a private capacity.
And as a member of the press, I hear you say that you've dealt with the press in a lot of different ways. What have those experiences been like, and how they've been different throughout these stops?
Well, my experience has always been with the press, and I think that you would agree that if you're treated fairly, you will be treated fairly back. Mm-hmm. And I think that there are certain things that as a DA or as a judge you can't say to the press. You're not authorized ethically to disclose it, or legally it's not proper. But if you can't do that and you explain why you can't do it, or you're respectful in terms of trying to answer the question to the best of your ability, and be as transparent as you're able to be, then I think that goes a long way with just building a rapport with the press. I think they'll treat you fairly as long as you treat them fairly. And that's been my experience, which has been very positive.
As you're able to be. That's a fine line there, though, right? And
yeah.
You have to know how far to go, but not go too far.
Well, you have to know ethically what each role has. As a judge, you're not permitted to speak to the press at all.
Right.
So that's an easy one, right?
Yeah.
As a DA, you're not permitted to give away information about the case that could harm a victim or disclose information about a defendant that can't be disclosed in a place other than a courtroom. And so you have to know the rules to be able to follow them. But I think once you follow them, then I think the relationship is easy.
I think that's interesting, that I know that judges can't speak to the press, but sometimes you almost feel like you probably want to, right? You probably wanted to over the course of your career, especially when you could look at, especially these days in 2025, or even in New York State over the course of the last few years when we had criminal justice reform. It's hard, even as the press, to really get a good sense of how the judges feel about a lot of this stuff, right? I'm sure as a judge, you probably felt the same way.
I do. And I think as a judge, you see a lot, you can't say a lot, but we all have feelings about criminal justice reform, discovery, bail reform, all those things. We can't say anything about them. My experience has been, at least upstate, is that the district attorney's offices comply with the discovery demands that are asked for. And typically, if they don't get something, the defense doesn't get something, then they ask a judge to make sure that they do, and judges order it all the time. I've given DAs more time to respond. I've given defendants, granted their motions to preclude evidence if necessary. I've delayed trials because they haven't gotten material. So you can work with the system. Judges need discretion, and that's the biggest part of this.
Yeah, so I guess maybe we'll get into that. I've got some other thoughts about, well, I did want to ask first about Saratoga County and how unique it is, a place that you obviously invest so much of your life. How unique is that to be a judge in, to be a DA in terms of the cases that you see, and in terms of some of the different dynamics that are at play there?
Well, I think as you would agree, the Capital District, Saratoga County, is a great place. I mean, it's safe. It has a high quality of life. Standard of living is good. However, we have our share of crime, and the crimes that I think have always stuck with me are crimes involving children. That Charlotte Senna case where Craig Ross abducted her from the Moreau State Park not so long ago. That case really took a toll on all of us, and sentencing that man to 47 years to life was the right outcome for that case. But you don't forget cases like that. Going back a long time ago when Lindsey Ferguson, the track star, got abducted from the Saratoga Springs High School right after practice, and the coach tracked down the defendant. He was prepared to I think, kill her. And there was a show on TV about that case. And he received a very lengthy sentence. So I think that when you have crimes that shock the conscience and shock the community, you deal with them appropriately and hand out appropriate sentences for people that commit horrendous crime. I think it acts as a deterrence. I think it is fair for the community and for the defendant. And I think it sends the right message.
As the days are going on in cases like that, like you said, how, I guess, for a judge, what are you doing every day to make sure that you're locked in? I guess at the end, because obviously there's a lot at stake, at every single case. But like you said, those are some that stuck out. What do you do, and what do other judges do to make sure that they are continuing to be able to disseminate the information and make sure that the decision at the end of the day is the right one?
Right. I think that, if your rulings are fair, you always have to be prepared. So, we do lots of reading. Our day ends at, 5 or 6 o'clock or whatever, and we read well into the night to prepare for the next day. We talk to juries after they render verdicts. What did you like about the case? What did you not like about how the judge or the people treated you? Did you believe this story? Just to get a sense, kind of a consumer feedback survey from jurors. And also, if we want to say something publicly, we say it from the bench in an appropriate and relevant way. So we can speak about things that we think are important the public should know if we're on the bench and we're communicating it in a way that's legal. We just can't do that outside the courtroom.
Those cases you mentioned are years apart. How, I guess, did you see the justice system change in that time, even when it comes to the people, technology, whatever it might be at hand?
Yeah, well, the criminal justice system changed dramatically. I mean, back when I first started in 1988 as an assistant DA,
I was born.
I was in my right. Okay, I was in my late 20s, and in those days, you sold a small vial of crack or cocaine, you went to state prison, no questions asked. There was mandatory sentencing. This was before Rockefeller drug reform, and the sentences were harsh and excessive. I testified before the New York State Assembly and Senate about modifying those laws long time ago. to the point now where we have drug courts and we have treatment courts for people that have addictions. And that's the right thing to do, and we've evolved as a society about that. Still people who deal and prey on kids and on young adults, certainly we can hand out appropriate lengthy sentences for those people. But addicts that are supporting their habit, that's a different thing. And that's been a societal change from way back in the 80s.
What about the difference in technology?
Technology is a lot different. Now prosecutors have an enormous burden to provide relevant documents to the case, to the defendant. As you know, in the legislature, they're talking about relevant. What does the word relevant mean? Does it mean relatable? Is it germane to the case? What is that definition? And so I think the legislature right now is going through that decision, and in the next day or so we should know something more about that.
Yeah, I wanted to get more in. I think that you bringing up the Rockefeller drug laws and the reforms. I want to get into that a little bit more, but you bring in the discovery discussion that's going on right now as the state budget. Whenever this airs, it probably won't be done.
Yeah, I don't know.
when this airs tonight. But so you look at some of the issues at hand when it comes to this. And you've seen some of the conversations I've had. I've spoken to individuals on a lot of the sides of this. And, they're very passionate on both sides of this. And you're a judge. But from what you've seen, and even in your time as a DA, let's start with those words, relevant, related. You just mentioned that. Why is that so important? Why is there so much weight to the difference between evidence relevant to charges compared to related to charges?
Right. I think the standard right now is related. So related can be anything.
Yeah.
What is related? And I guess ultimately we hope a judge decides what is related.
Yeah.
Prosecutors have a tough time with that. I remember back in the day, if a police officer wrote out names of witnesses on a scrap piece of paper and then transferred those names to an official report and threw away the scrap piece of paper, then that could cause reversible error. Thankfully, we're not at that stage anymore. There has been some changes for both sides, both for prosecution and defense. I think the way the legislature should go is to be relevant information. It has to pertain to the case, that particular case, not just any case about the defendant. And I think that's the difference. I saw Lee Kinlan's comments recently, and I think he's spot on. I think he's described a situation that is fair, that is reasonable. Cases upstate are not being dismissed. It's mostly downstate cases. My experience has been I've always given more time if more time is needed. If there's an earnest, good faith reason for it, I've given them more time. On the other hand, I've had to, in certain cases, preclude evidence from being offered at trial if I felt like the prosecution was not providing the evidence in a timely way.
Where does People v. Bay, which if you guys watched last week, Lee Kinlan and I spoke about that at length, just discussing what that meant, what that decision meant. And I know that those that are on more the defense side of keeping these discovery reforms the same have said, well, we just need to codify People v. Bay, which if you want to explain it, I'd probably do a better job than I do. If you've read, I'm sure, that case and what that decision was, if you want to explain that for us.
Sure. Well, I have read that case, and I think, sometimes the criminal justice system needs to be able to be changed, right? It can't be absolutely 100% solid without ever changing. And I think we had years and years and years of no change. And so as a result, the pressure to change the criminal justice system became overwhelming because things were just simply not fair anymore. On the other hand, we can go too far. And I think we did that in the initial bail reform stages, where we had people that went out and committed burglaries and then were released on RORs and then committed a new burglary and were released again and again and again. So that needed to be changed. So I think sometimes the pendulum needs to swing back a bit, but codifying the discovery statute is important for prosecutors to know institutionally what they need to do in every single case.
Right.
And I think as long as they know what the rules are and where the line is, they're going to follow it.
Other options other than dismissal, how would someone like you disseminate that and decide what that would mean? Who's calling the balls and strikes there?
Well, the judge does.
Yeah,
and it's always based upon the arguments that are before the judge, the prosecution and the defense. It's based upon the material that's submitted, what happened in the case as well, and then obviously the case law that applies to it. Dismissal is the ultimate sanction, right? Once you dismiss, it's over. And unless there's a bad faith, purposeful ignorance of the statute, then I think that time might be for a dismissal. But mostly the experience I've had is that there's so many moving parts in these cases. Hundreds of people touch these cases: law enforcement, social services, DAs, investigators, all kinds of people. And you have to be aware that it's not easy to get all that material in one place to a defense attorney within 15 days of arraignment. And that's the problem. And I think if there's a reason why, and it's articulated in a thoughtful and documented way, I think a judge would very easily be able to decide, I'll give you more time. I'll adjourn the trial. I'll give defense additional time for their discovery. So you can be fair about it without the ultimate remedy of dismissal.
Right. And I think those that have fought for these reforms are, I guess, would be concerned that they would go too far, right, in terms of allowing the case to go on, and then you have pre-2019, right?
Right.
I think that's where I think there could be some gray area and some concern among those that are saying, well, now you're allowing more leniency here, right, at the end of the day.
Right, and I think the danger is taking discretion away from the courts, because the courts are kind of in the trenches. You know, we see the cases every day. We know who the attorneys are, both prosecution and defense. We see what the track record has been, not only in this case, but in other cases as well. And so, you know, you like me make judgments based upon experience, contact, what you see, the credibility of the witness. And so you can make decisions based upon that, I think, that are always fair, given what you see as in a courtroom.
So you do think that in 2019 reforms were needed?
I think that, yes, I think in 2019
in discovery
reforms,
specifically.
In discovery. Because defense was flying blind a lot of the way, and that was difficult. I think that there needs to be more tweaking, though. It's never done. And I think at this point, the burden on prosecution is enormous. And I think that there's got to be a way to be able to accommodate the requests of the prosecution and the defense with something other than outright dismissal.
Let's get quickly to bail reform. I know it's not really a conversation right now at the Capitol. It has been since 2019, and there's been changes, tweaks to it, I think 2 or 3 at this point.
Right.
Should dangerousness be part of that?
So
be considered for a judge?
So many states do consider dangerousness, obviously. One of the things that we look at is ties to the community. And I have always said, and this is kind of counterintuitive, that the people who have the money have ties to the community. So aren't we really saying that people who have no ties to the community, people that are indigent, homeless, you know, are we treating them differently? So in essence, is that a double standard as well? So you look at dangerousness, is that not necessarily a better way to look at it? Because ties to the community is really, I think, defines someone by their socioeconomic status. And that's not what we want either. So I don't think there's any right answer. I don't think it's an easy answer. But I think that judges should be able to consider dangerousness in an appropriate circumstance.
Can they do it without using that word now? With what's in the wording of the legislation? Because I know a couple years ago there was a list of different things that you could look at, and then least restrictive means is in there now.
Right.
I mean, is dangerousness already, I guess, implied?
Well, you know, dangerousness is kind of the elephant in the corner. I mean, you know what the charge is, obviously. The person in front of you is presumed innocent by the Constitution. They are sitting there just like you and me in a courtroom. They're presumed innocent. So you can't consider, you know, the fact that they are charged with a murder, for example. You can consider what the potential sentence range would be if they were to be convicted, and if that, in fact, equates to likelihood of fleeing the jurisdiction. You can consider what are the likelihood of success on the merits of the case. You can consider ties to the community. Those are the kinds of things that judges can consider. You just go down the line. And so we do that, and we follow the statute.
Do you think judges are always doing that? I mean, I guess I ask that. You hear a lot in the national level, local level, that judges are politicized. And I look at the case of Lola Saratoga, which was about a year ago, where the individuals was one of the times that they were burglarized, stole some purses. The individuals were from D.C., and they had records, they had other issues in D.C., but the judge at that time said the great state of New York. Is that a political statement of allowing them to be out on bail? Well,
I think it's not necessarily a political statement. It's the reality on the ground, right? I mean, the judge could not hold those defendants.
But why didn't he look at those factors of they lived outside the area, they did something bad. You know what I mean? They had priors that they could have been looked into.
Right.
But why wasn't that considered is my question.
Because in burglary third degree cases, like those were businesses, burglary 2 is house, burglary 3 is business. Burglary thirds, you're not permitted to hold defendants, no matter what. unless there are certain things like injury to someone in particular or some identifiable cause. But under a burglary through of the Lola, for example, those defendants had to be released given what the judge knew at the time. So the judge was not happy about that, obviously, and I think we could say that the judge made a political statement, but that also happens to be the truth of the statute at the time. And, do we need to reform that and look at that again? Perhaps we do.
So the charge itself superseded some of those other factors?
Exactly.
Because I spoke with some lawmakers who worked on bail after that, and they're like,
Right.
I thought that we accounted for this,
Well,
is what they said.
Perhaps, so there's this, we're getting a bit in the weeds, but burglary twos used to also be cases that had to be released initially. That's burglaries of homes. And it related to package rooms in New York City apartment buildings, which really didn't apply to anything north of the Tappan Zee Bridge.
Right.
So all of a sudden, upstate homes and garages that are attached to homes of burglaries were cases where judges could not hold. And so that needed to be changed. And then they switched it so that it was Berg 2 but not Berg 3rd. And that's the problem. Berg 3rds need to have some additional, if you are a repeat offender, if you're out on bail on one and do it again. Those are the kinds of things.
Interesting. We talked about politicization of judges, potentially. I know obviously that's a big topic right now nationally.
Right.
So I wanted to ask you, I think people are a bit maybe confused, just need to learn more about this process. You see Donald Trump issue an executive order, and then you see a district judge, a federal judge somewhere put a stay on it or say, this isn't right, whatever they might want to do. What is that process? What does that look like?
So one of the things I think judges across the nation are having trouble with, and perhaps the public at large also, is that why are judges' orders not being followed, right? The way that our society, a democracy, works is the judiciary is a separate and distinct branch. It makes decisions about cases, it rules, and then those rules are enforced. Yeah. What happens when the rules are not enforced? Judges don't have any independent authority to go out and enforce their order. It's typically enforced by, the U.S. Marshal or the government or the people of the state of New York or the United States. So when judges issue orders, we expect those orders to be followed. If you don't like the judge's order, you appeal it. You don't ignore it. And that's the proper method. And if you want to stay the decision, you apply to the appellate court to stay the lower court's decision until the appellate court has a chance to rule. And that's granted all the time. It's respectful of the system. It's the way a democracy works. And it's the way our judges should be treated.
We've heard from elected officials that the highest rankings of government say, well, why should it be fair for a district judge in New Hampshire, one person to be able to challenge this and stop this? Why is
okay.
How does that happen? Why is that the case?
It's because it's the way the system is built to work. So a district judge, a district court judge, which is the trial level judge on the federal system, makes decisions about statutes in his or her courtroom. And since they are national laws, it applies to the national landscape. And so a judge in New Hampshire who finds a statute unconstitutional, it applies to the statute, not just to the statute in the state of New Hampshire. Versus in our situation, my court, it applies only to the state of New York.
Right.
And so it's really jurisdictionally based, and it has greater effect. It gets more press coverage, but it's basically the same thing. It's just the way the statutes are. They're national statutes, they're federal statutes, and the judges rule on those things.
This might be a basic question, but how does it come across that judge's desk? How does this come up for them?
Well, you need to have some nexus to the jurisdiction,
Yeah.
So it has to be filed in that court because there has to be something that ties it to that state or to that district.
Right.
And if it doesn't, if you're forum shopping, then it gets dismissed without a claim to that particular area of the country.
Do you believe there is any political backing behind some of these?
Well, I think, people who file lawsuits in different places of the country always have a political bent to them in addition to wanting to have an outcome that is beneficial to them. So I think that's certainly a factor. But it's the judge's job to find that. If there's something in there that's not properly argued or that doesn't have a nexus to that community, then the judge is dismissing it and say, go file somewhere else.
Interesting. I want to get back to some of the work that you've done over the course of your career. When it comes to domestic violence, you mentioned the Rockefeller drug laws and drug treatments. Before we get to the Rockefeller part, I did want to ask about the domestic violence aspect of your tenure and why that became such a big thing for you to kind of help, not amplify, but provide resources and infrastructure for people that might need help there or guidance in that aspect.
So, as a DA in the trenches, I saw hundreds and hundreds of cases of domestic violence. Yeah. And back in the old days, when I first started, we didn't really treat them any differently. We often said, oh, it's a husband-wife or it's a boyfriend-girlfriend, and, do we really need to get into this? And it would often be switched over to family court, which is astonishing now to think back of that. So then all of a sudden, places like domestic violence services, created places for victims of domestic violence to go to seek help, counseling, treatment, legal advocacy, and DAs operated and began funding victim impact units and what people in the DA's offices to help victims of domestic violence, and then worked with shelters and worked with places all across the country, really. So it went through a sea change, much like DWI did in the 80s and 90s, where in the old days people would say, oh, it's a drunk driving case and kind of shrug their shoulders, and now all of a sudden people are held responsible for drunk driving.
Interesting. The Rockefeller drug laws, how... You looked at those, right, back in the was it early 2000s, I think it was, and saw a need for those to change. How is that different than what happened? I guess how is that different in terms of what happened in 2019 with some of the criminal justice reform? Those are two major movements in the state over the course of the last 2 decades or so.
Sure.
And a lot of it was meant to, one way or another, level the playing field, not to make sure that certain populations weren't impacted disproportionately. Can you just kind of separate those, or I guess what if you look at those through a microscope? How does that look to you?
Right, sure, and that's a really good question because they seem very similar in terms of the kind of reform that we're talking about, but in essence, they're very different once you kind of pull back the first layer. So the Rockefeller drug reform really focused on sentencing change, right? Judges had no discretion in sentencing under the old pre-Rock reform statute. So if somebody was charged with a sale of cocaine or crack, no matter what the quantity, it was a B felony, and it was 8 1/3 to 25 years in prison. I mean, that is astonishing to think about that. And that was mandatory. Judges had no discretion. Post-Rock reform, the sentences were lowered. So now judges can sentence, to as little as probation. The prison sentences are still available to them, but they're nowhere near the 8 1/3 to 25. They're maybe 3 to 9, something like that. The discovery reform relates to the conduct of the attorneys, right? The attorneys have to do certain things based upon the statute and discovery. So prosecutors must, within 15 days, turn over the entire file. One of the things that's always concerned me, and I just throw this out, is that they disclose at that time the witnesses that are going to testify against the defendant. That's always a dicey situation. Now, mostly people don't care because there's no connection, but if it's a case where they're not aware of who their complainant is, who the victim is, or who the witness is, it does and can place the victim in some jeopardy. And so there's that to be considered. And I think we need to bolster, judges' ability to and DA's ability to kind of protect victims who want to come forward, but don't want to have their name out there within 15 days of that arraignment. It's really early on compared to where it used to be, which was after the jury was sworn.
Right.
So at trial, really. So it moved it a year up.
How is bail reform different than the Rockefeller drug laws?
So bail reform is really about a pre-conviction stage, right? The person that you're wanting to hold has not been found to be guilty of anything, right? They're just like you and me. And so they have all of their constitutional rights, all of their fundamental rights to equal protection and fairness. And so to deal at that stage, you have to be very, very careful because Rock reform dealt with people that were convicted and sentenced. Discovery reform related to the conduct of the attorneys. Bail reform relates to people that are innocent. And that's why it's so careful.
Right.
You have to be so careful.
Innocent until proven guilty.
Exactly.
Which is what a
exactly.
lot of this is founded upon.
Exactly.
Interesting. The other aspect of discovery that I did want to ask about was we talked about technology earlier, and the body cam surveillance camera. How much has that changed the process of discovery?
It's made it much better. I'm a big proponent of police-worn body cameras, and I record statements of defendants being recorded in police departments all across the state. Defendants often claimed that they had been beaten or coerced or tricked into giving a confession. Once those police agencies started recording those confessions, all those motions to dismiss for those reasons went away because defense attorneys could see exactly what the police did. And if the police did something bad, that was recorded also. Obviously, police have to record. It's the law. If they don't, the case gets kicked. We see all these horrible situations now in prisons where these corrections officers have done horrendous things, at least for allegations of horrendous things.
Yeah.
So recording, I think, is the best way to go because we can see it with our own eyes. We know what happened in those investigative rooms.
In terms of having that, in addition to some of the other evidence, turned over, should that process be changed? Now, that's another legislation that's been proposed that, especially down in New York City,
Right.
it's a big
Sure.
NYPD thing, but still, if you look at statewide potential laws, to have some sort of a streamlined exchange of material that happens to make it a little bit easier on the side of the prosecution.
So the way that we deal with it upstate, and this is across many, many police agencies, it's seamless. You take your body-worn camera off, you put it in the slot, it downloads it immediately overnight. The next day you put it back on. It activates when you're in a situation that it either needs to be activated or it activates because of the car lights going on.
Yeah.
And so I think initially the resistance police had, because it was new and they were not sure, and like anything, we don't like change. I think they have embraced it because it protects them as well. It makes sure that false allegations can be met head on. Here's what I did, and you can watch it and see it. And so I don't think there needs to be any change with regard to that. Now, downstate, the New York City Police Department is an entirely different animal. I don't know how their situation works, but I know the state police and the sheriff's departments and the local police agencies upstate meet the requirement, and we haven't had any issues with them.
Should this be considered when now looking at this discovery process of the time it takes to go through all of that?
Well, it is a lot of material. It is a lot of material, but the question is how much time is too much time, right? I mean, if someone's liberty is at stake, shouldn't we know exactly what happened in that particular case? And I think the answer is yes.
So you've been retired now for how long? A couple months?
3 months, yeah, very quick.
How's it been going?
It's been great.
Yeah.
I feel like when anybody retires, they think, what am I going to do? How's this going to go? And Being Communications reached out and said, would I be interested in working with them, talking to clients who sometimes have legal issues, sometimes have personal issues, sometimes have just complicated situations that they need advice on. And as a DA, as a judge, I've given advice for 37 years. About the criminal justice system, about the legal system. I know lawyers, I know judges, I know all kinds of people in the community from living here for such a long time and being from this area. And so I find it extremely rewarding that I can kind of continue to help people, just not in my role as a judge or as a DA. So in a way it's freeing because I don't have the ethical restraints that I did as a judge, and I can help people in a private way and take the cases that I want to.
Right, because I feel like as a judge you're much more under the gun. There's pressure attached to making sure, probably some anxiety attached to that. Obviously in this business we feel that too. Like
Sure.
There's a responsibility there. Of course you have a responsibility now, but I'm sure it's a little bit different now for you.
Right. I feel like in the judicial world and as a DA, every decision you make is scrutinized by the public, by the press. It's the lead on the 6 o'clock news. Crime is always at the forefront of what people are interested in learning about and hearing about, not only because it's interesting, but because they want to be safe in their community. And now that I'm stepped out of kind of that light, it's a bit of a relief, but I can feel comfortable that I can deliver the same kind of services and help that I gave as a DA and a judge, just in a different way.
Any decision you do differently? Or any case you would do differently?
Well, one of the things that I've done, and I know that the legislature is considering this, is the anonymous juries. So I had jurors come to me during the trials of cases where defendants were charged with serious, heinous crime, and said to me that they were afraid that the defendant would know or would have a way to know who they were. So I granted, with the consent of both sides, a way to give the jurors numbers rather than their name. And appellate courts didn't like that. They said that's not proper. You needed to provide all the names to defense. I think, and I respect the decision of the court, but I think that they don't understand the situation that you see at the ground. Jurors are really afraid. And it wasn't that we were saying, we're not going to tell you that this person's a juror. We would say, this person is a juror from Wilton that lives in that community, the age, the date of birth, all of that, but just not the name. And so the legislature is considering right now an ability for courts, in appropriate circumstances, to have trials where jurors are anonymous. And I think that's a very important thing.
Yeah. Moment you're most proud of, or is there a time that you've been really, you get home and said, okay,
Well,
that was a good day.
I mean, a thousand cases later, it's hard to pick out one thing.
Yeah.
I mean, a highlight case is this horrible Dennis Drew case where he killed 2 Shenandoah students and seriously injured 2 others. We prosecuted that case. He ended up getting a lengthy sentence. Now he's out years later in the news again.
Yeah.
I know he just had his case dismissed in Colony Court.
Yeah.
I don't know the details of that. I don't second guess that judge. I'm sure the judge made the right decision. But I do know that back when we made the decision to prosecute him to the maximum extent, it was the right thing. And I think here we are years later realizing that we made the right decision back then.
I guess that's a different conversation about parole, right? At the end of the
Yes,
day,
that is a different
that might be
conversation.
a different
Yeah,
conversation
yeah.
for a different day. Jim Murphy, thanks so much for your time.
Thank
Appreciate
you.
it.
Thank you. It's been a pleasure. Thank you for having me.
Thanks for listening. Hit the subscribe button right now so you can stay up to date on these news-making conversations about the issues impacting New Yorkers the most: power and politics.